By the second day of trial, the defense attorney has made about 50 different legal objections. Is there any limit to how many objections an attorney can make during a trial? You want to know the answer? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. The answer is no, there is no limitation on the number of objections an attorney can make. But I will tell you, making objections just for the sake of disrupting the attorney is a very bad strategy. You want to know why? After the first few times, everybody will be curious and interested to learn what the objection is. What's the problem with the question? What's the problem with the evidence? But now, by the 10th, 20th, 30th, 40th time, 50th time, everybody's getting tired of this attorney jumping up out of his seat. Objection, Judge! Now it will become crystal clear to everybody in the courtroom, including the jurors, that this defense lawyer is making these objections only for the purposes of obstructing the questions going forward and getting the evidence in. That's what will become crystal clear. And a novice attorney who does that runs the risk that the jury will take it out against him and his client. It's not a good strategy. You have to know when to make an objection, and even though you may be legally right in going ahead with an objection, some of the best trial lawyers in New York turn around and say, you know what? I don't really need to object to that particular issue. I'm just going to be quiet. Because sometimes when that happens, when the attorney takes that strategy, now the jury just glosses over it. They don't pay attention. It's not being highlighted. So the moment an attorney makes an objection, everybody's ears perk up. They wonder, what's the problem? Why doesn't the attorney want this question asked? Why doesn't he want this piece of evidence introduced? And now he has to explain to the judge his reasoning. The judge then has to take a moment to rule on this issue and either allow the question, allow the answer, or allow the evidence in or not. But an attorney who jumps up over and over and over again, did you know that an attorney has to stand up and yell out objection if he feels that something is going wrong and now he has to protect his client's rights? You have to stand up and give the court the respect that they're entitled to. So now the jury's going to see right through it. If he's objecting 70 times, 80 times, 100 times throughout the course of the trial, it's not the best strategy to take. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in trials involving accident matters and medical malpractice matters and even wrongful death matters here in New York. You know, I understand you're watching this video because you have questions or concerns about your own particular matter. Well, if you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.